Generally speaking, everyone in the UK has the freedom to leave their estate to whoever they'd like to after they die. However, when a person dies, whether they've left a will or whether they've died without having made one, certain people are eligible to bring a claim against their estate if they feel that no reasonable financial provision has been made for them. These claims are brought under the Inheritance, Provision for Families and Dependents Act 1975. So who's eligible to bring a claim under the Act? Spouses and civil partners are eligible, as well as cohabiting partners, children of the deceased or those treated as children of the deceased, and anyone who's financially dependent on the deceased. Before bringing a claim under the Act, it's important to consider what constitutes reasonable financial provision. When the court's considering these claims, they'll look at the factors set out in Section 3 of the Act. These factors include current and future resources and needs of both the applicant, any other applicants, and anyone who already benefits under the deceased's will or by the rules of intestacy. They'll consider the obligations and responsibilities of the deceased to the applicant or any other applicants or beneficiaries. They'll look at the size of the estate, the assets within the estate, the value of those assets, and any capital. And the court will also consider any other matters they feel to be relevant. This may include conduct of the person bringing the claim, the nature of their relationship with the deceased, their age, or their employment. It's also important to note that there's a deadline for bringing claims under the Act. The deadline is 6 months from the date of the grant of probate being issued. If a claimant wishes to bring a claim outside of this deadline, they'll need the permission of the court to do so. Applications to bring claims under the Act out of time are rarely permitted, and therefore the applicant would need to present very good reason for why there was a delay in them bringing their claim. The most common claims we see are from cohabitees and adult children. Claims by adult children are notoriously difficult to succeed in. Often this is because the adult children are no longer maintained by their mother or father prior to their death. There may have been an estrangement within the family, or they are independent and financially secure on their own and have children of their own. There have been a few cases recently which have brought adult child claims under the Act into the spotlight, and these have muddied the waters in trying to predict the court's approach to these claims. It's important to note that each claim turns on its own facts, but arguably adult child claims are strengthened where the claimant is not financially stable and has a living or housing need. They perhaps have retraining or education costs to lead to better future employment prospects. They may have a disability preventing them from earning a living themselves, or they may have current or future care costs. Similarly, there have been a rise in recent claims brought by cohabiting partners in a relationship with someone who has died, particularly where someone has not left a will and the intestacy rules apply, meaning that the person's estate is distributed to certain intestacy beneficiaries set out in an order in the intestacy rules. Cohabitees are not included as an intestacy beneficiary. Therefore, in a situation where a couple have been living together for many years, pooling their finances and living together as husband and wife or civil partners, and one person dies suddenly without leaving a will, the surviving partner will not automatically benefit from the estate under the intestacy rules. To be a qualifying claimant under the Act, the surviving partner must have been living with the deceased as a couple for at least 2 years immediately before death. The court's attitude recently in respect of cohabitee claims has been to focus on the accommodation needs of the surviving cohabiting partner, as well as their need for financial maintenance. The courts have recently shown a tendency to award what is called a life interest in a property to a surviving cohabiting partner. This means that the surviving partner can remain in the property where they were living with the deceased for the remainder of their lifetime, after which the property passes in accordance with the deceased person's will or as per the rules of intestacy. In terms of financial maintenance, depending on the age of the cohabiting partner, it's unlikely that they will achieve an award equivalent to full financial maintenance for the rest of their lives. However, various factors, such as their own financial position, ability to work and earn a living themselves, any care needs they may have, and the length of the relationship and time spent living together will all be taken into account. It's important to note that when making a will, careful consideration should be given if you wish to leave out a child, partner, or dependent. This could mean that your chosen executors are faced with costly litigation later down the line, which essentially will eat into the value of your estate and ultimately lower the distributions made to your loved ones. If you would like further advice in respect of claims under the Inheritance Provision for Families and Dependents Act 1975, whether as a potential claimant or an executor for an estate of someone who's died, please contact my team at Shakespeare Martineau for further guidance. Thank you.